Nnamdi Kanu'S case, the national proceedings, and the relevance of rule of law. As other serious cases, Nnamdi Kanu'S case has entered a position of case study and reference. It is not ordinary case. It is a political cum judicial rock being played out like a replica of apartheid system controlled by the executive authority in the old South Africa. As a far-reaching arguments and the relevant judicial decisions are made, a careful study of the argument and the decisions have human rights correlations and violations of its articles. In this very case, we will look and review what transpired and how it correlated the human rights conventions and the violations of its articles. This becomes relevant and directional from national to international applications of human rights laws or conventions, relevant member nations and the signatories rectifying such treaties and protocols. Mr. Kanu'S case becomes most relevant because it involves and revolves between the human rights abuses, violations of relevant treaties, and the criminal allegations. At international level, it revolves around United Nations protocols establishing human rights conventions which are binding to all nations that signed and ratified such articles or conventions. There are 3 regional courts representing United Nations on implementation of the established articles at each relevant continental levels, such as the European Court of Human Rights, called ECHR, the Inter-American Court of Human Rights, and African Court of Human and People's Rights. In their duties to ensure justice and equity, these mentioned courts meet annually to review and evaluate their legal operations. In studying their procedural methods and case admissions, it appears to be the same, but what may be relevant or relatively different is the ability to be independent in delivering judgments without being influenced within the individual continents. The purpose of this program is based on the case of Nigerian government against Mr. Nnamdi Kanu. Nigerian Supreme Court sat on the case recently and gave a verdict which pleases government officials, Mr. Kanu's foes, but displeases lovers and sympathizers of IPOB leader, Mr. Nnamdi Kanu. In this very program, the crucial question is Nigerian Supreme Court's decision final? The answer relatively is no. It is no because it is a human rights case. It involves human rights, and all the arguments throughout the period of proceedings were circled around the human rights violations against Mr. Kanu by the federal government of Nigeria. Coming back to the background of the case that determines the fact that the Supreme Court of Nigeria is not the last option, but the beginning of the new proceedings. But before we go further, we will go back to the background as summarized by the Supreme Court of Nigeria. See the background. Mr. Kanu, the IPOB leader, was first arrested in 2015 under the administration of the then President Muhammadu Buhari. 2. The Court of Appeal, Abuja, on 13th October 2022, held that IPOB leader was extraordinarily rendition to Nigeria and that the action was a flagrant violation of the country's extradition treaty and also a breach of his fundamental human rights. The court therefore struck out the terrorism charges filed against Mr. Kanu by the Nigerian government and ordered his release from the facility of the state security services. But the federal government refused to release the IPOB leader, insisting that he, Mr. Kanu, could be unavailable in subsequent court proceedings and that his release will cause insecurity in Southeast, where he hails from. The federal government, through the Office of the Attorney General of the Federation, later appealed the court ruling and subsequently obtained an order staying the execution of the court judgment at the Supreme Court. Then finally, delivering judgment on the appeal on 15th December, the Supreme Court reversed the acquittal granted to Mr. Kanu by the lower court and consequently ordered continuation of his trial at the Federal High Court, Abuja. This is where the relevance and the beginning of the new proceedings. This brings us back to the establishment of the 3 regional courts by the United Nations to look into the issue of human rights abuses and violations of individuals, the citizens, and also determine if the government of each state that signed the protocol to protect human rights did violate such articles. The Human Rights Regional Courts made it known that before a case is brought to it, the highest court of the land must have had the opportunity to look into the cases. That means appeals must have gone to the Supreme Court, after which it can be referred to it. The simple reason the court made this known is that it should be pleaded to a state's highest court before an application is made to the court to avoid the risk that the court may otherwise declare application inadmissible because of the failure to exhaust domestic remedies. The 3 regional courts made it known that the convention only requires exhaustion of domestic remedies, which are relevant to the alleged violations, which are adequate and effective to redress them. This means in Mr. Nnamdi's case, the exhaustion of all effective available domestic appeals have been made, and it is the lawyers now that have the opportunity to forward their case to the highest court in Africa for review, who can bring this case directly to the court. The case may be brought directly by a victim. It can also be brought to the court by his lawyers or NGOs on behalf of the victim or individuals. For the lawyers, it is very, very advisable to plead breaches of specific articles of the Convention, including if a violation of the right to trial within a reasonable time of the Convention is pleaded in the context of national criminal trial. The remedy sought should be clearly stated: termination of the proceedings or recognition of the extenuating circumstances, which are the alternative consequences of a violation or consequences for violation of the right to a fair trial under the court's case law. Therefore, the court stated, in making this application, citations of the court judgment must be fully referenced, including the specific paragraphs concerning the interpretation of the convention relied upon, and also the decision of the court from which the case was determined regarding the violations of the articles of the convention. With this, they should also indicate the violations of fundamental human rights that is raised in the court. Thank you very much for listening. This is a piece where one has to deliver in order to make reference of the case back to the African Court of Human and the People's Right for review for the violations Nigerian government has meted against its citizens, not only on the issue of Mr. Kanu'S case, but also other cases. In Europe, the European Court of Human Rights are always out to deliver the right judgment based on the violations of the European Convention of Human Rights. It is expected that also that the African counterpart will march with the same preparedness and openness in delivering their judgment, especially as they review their cases together at every end of the year. With this, we come to the end of this very program. We hope this will help to determine the case against Mr. Kanu and the violation of his fundamental human right that has been denied by the Nigerian government based on individual grievances rather than the protocols of the convention. Please do not fail to subscribe, share this video to your loved ones. Remember your thumb up, and also do not forget to comment. Thank you and God bless you all. Bye. Hi everyone, you're welcome back to Massive Media.